Welcome to the Far and Beyond podcast, hosted by the Contracts and Fiscal Law Department at the Judge Advocate General's Legal Center and School. This podcast is for federal government attorneys navigating the complex intersection of acquisitions and fiscal law and policy. I am your host, Major Ellie Sewell.
And I'm Major Jason Floyd.
And I'm Major Ed Callahan. Together, we are your co-hosts. On this episode of Far and Beyond, we're diving into a topic that is having a big impact on the defense industrial base. DoD's new and newly finalized Cybersecurity Maturity Model Certification, or CMMC rule.
It seems like a massive regulatory shift, and it presents a whole new set of challenges and responsibilities for government counsel. To help us navigate this, we've brought in JAGC's local expert, Jason. Welcome to the show.
Happy to be here, Ellie. You are right. The new CMMC rule is at the top of every industry counsel's mind, and it's essential for government counsel to get ahead of the issues as well.
So, Jason, let's start with the big picture from the government side. We know this is about cybersecurity, but what legal problem is CMMC designed to solve for the DoD?
Yeah, great question. So in recent memory, DoD has seemingly struggled to enforce its cybersecurity standards. We relied on this sort of self-attestation model where the contractors simply promised that they were compliant with a standard like NIST 800-171, which comes from the National Institutes of Technology.
What does that say, though? What is NIST 800-171?
Yeah, great questions. For those that are unfamiliar, it's essentially a set of rules that are not obligatory because the NIST doesn't actually regulate anybody, but to the extent they're included in our contracts, they force the contractors to abide by those rules. And we'll get into what a couple of those are later on, but just knowing that it's a set of rules for cybersecurity specifically is important.
Okay, Jason, but you say they seemingly struggled. What does that mean?
Yeah, so the model only really works to the extent that the contractors' attestations were accurate, right? So DoD didn't really have a contractual mechanism to verify such accuracy because we couldn't really look under the hood, as it were, of their cybersecurity programs. We had to just trust that they had those in place until a cyber incident occurred. The new rule still requires that self-attestation, but for some kinds of sensitive information, we will also require independent verification.
Okay, so you said certain kinds of information. Is that defined somewhere, or is it kind of just left up to the contracting officer to define it?
Fantastic question. The rule specifically lays out a three-tiered system. The first tier is concerned with what we call FCI, or Federal Contract Information. The second and third tiers are reserved for or triggered when the contractor possesses CUI in accordance with the contract activities that they are to perform, and that's controlled unclassified information.
So we've been working with CUI for a while here on the green suitor side. With the federal contract information, those both seem like pretty broad categories of information.
Yeah, you got it. And that's typically because the problem we're trying to solve might encompass a lot of cybersecurity issues, right? So the terms are broad, they capture a ton of contracts, and that's why it's important for the practitioner to understand the rule and its applicability, right? So as a contracts law practitioner in the federal government, you will come across this. And it's no longer just about reps and certs being a block check, it really is about diving into the material. So the two important definitions are FCI and CUI, right? FCI, you're going to look in FAR subpart 419, and it lays out the definition there. It's essentially information that's not intended for public release, that's provided by or generated for the government under a contract. That's all it is.
It's just not my field of expertise, and that still seems pretty broad to me.
You're right. Yeah. And CUI is no less broad, right? Because while it is a bit more narrow, it covers, less information. For its definition, we're essentially going to include all unclassified information throughout the executive branch that requires any safeguarding or dissemination control. And we find that information in Title 32 of the CFR, right? And so now, the DoD, as the relevant executive branch agency, gets to fill in the blanks into what exactly is in the contract that's going to be handled by the contractor that fits the definition of CUI. And DoD, as we all know, has an entire website dedicated to those categories and subcategories at CUI.
When you guys were taking trainings to deploy, do you guys have to take all those trainings where you go through all those subcategories, and like I felt like there were hours of learning about CUI and all the different categories that fell under CUI.
Yeah, and not just for the deployments. I've had to do it a few different times to include when they just brought them all into the Outlook, into all of our emails now. We got to make sure that we're appropriately labeling every subcategory. I don't know if you've had to go through and label any CUI.
Oh, yeah.
But there's an entire secondary menu of which you have to identify which category of CUI that actually falls into. I mean, there's stuff like defense information, which includes all the technical information, blueprints, data, software, Privacy Act information, proprietary business information. CUI is a broad category.
Okay, so once I determine whether the contract involves FCI or CUI, what's next?
Yeah, so once the contracting officer includes what information will be handled by the contractor, then they have to figure out which tier is required to be put into the solicitation. That is going to control what type of cybersecurity model is used and which assessments are required. For example, Tier 1 is going to rely on the clause at FAR 52-204-21, which has only 15 requirements, stuff like limiting authorized users, maintaining visitor access logs, scanning and correcting flaws in their security systems.
Only 15 requirements?
Yeah, they're not that bad. It's not onerous because, again, this is just FCI, which is pretty much any information that's not intended for public release.
So that makes sense, and I guess that covers just Tier 1, though, right? Didn't you say with the 3 tiers of them? I imagine it gets much more complicated after that. That's
exactly right, Ed. Tier 2 has 110 requirements in accordance with a separateness standard, which is 800-171 Romeo 2. That contains requirements like prohibiting certain kinds of removable media. It also requires an assessment by a C3PAO organization. That's just a special kind of entity authorized by the federal government to conduct these particular checks. It's called a CMMC, third-party assessor organization. It's also usually a contractor. That verification is required every 3 years. And then finally, Tier 3 adds on another 24 requirements on top of the 110, and lots more assessments. And those assessments are not done by a contractor. They're done in-house in DoD by a sub-agency of the Defense Contract Management Agency.
All right, so 110 requirements there, 24 more requirements there. Let's pretend, for just purposes of this conversation, obviously, that I'm not as smart as you. Where can I find these resources?
Well, Ed, I don't think we need to pretend. Sorry. Yeah, Ed, that's a critical question for government counsel, right? The CMMC framework is built on a dual rule architecture. First, a few years ago, you have the program rule, which came out in 32 CFR Part 170, which establishes sort of the what, right? The levels, the assessment processes, and the roles of the assessors. The text of DFAR's subpart 204.75 is also helpful there. Second, and most important, is this new clause rule that just passed. That created the clause at DFAR's 252-204-7021. That's the clause that's incorporated into the solicitations and contracts going forward once it becomes effective on November 10th, 2025.
Okay, so I'm going to be looking to have the program rule and the clause rule along with the text of DFAR's 204.75. But let's get practical. If I'm advising a contracting officer who's about to make an award on a contract with a CMMC requirement, what are the non-discretionary legal pitfalls that I have to be on the watch out for to make sure I advise my command?
That is a fantastic question, Ed. So the contracting officer's most critical but new duty is the mandatory verification. She must use the Supplier Performance Risk System, or what's abbreviated as SPRS, to check the potential awardee's CMMC status, right? It's a lot like doing a last-minute check to make sure an awardee's SAM registration has not expired right before award.
So this whole new idea landscape sounds like a prime area for legal challenges. So what do you think are the bid protest grounds everyone should be preparing for?
Absolutely. So this opens up several new avenues for protest. First, there's challenging the CMMC level itself. A protester could argue that the selection of, say, a level 2 third-party assessment was unreasonable, that it shouldn't be included as a requirement in the solicitation. To defend that, the agency's going to need a well-documented record showing a rational basis for its risk determination.
Well, what about the protests against the award itself?
Yeah, Ed, that's another major risk. A protester could allege that the awardee's CMMC status in SIPRs was not current at the moment of the award, or that their plan of action and milestones was invalid. That's why it's critical to advise your contracting officers to meticulously document their SPRS records check. A timestamp screenshot of the record in the contract file is now practically essential.
It kind of sounds like when they had to register with like SBA, and we were having issues where were they registered the full time? Did they just have to be registered at the beginning and at the end? And there was a lot of protests going on about that. I don't want to say protests, but a lot of discussion. This sounds similar to that, where they have to be current at the time, but they're just saying just at award or at proposal submission.
Yeah, that's a great question. So it's going to be both times where you're going to have your CMMC status there, right? We don't know for sure how the different fora are going to come down with respect to requiring this at the same time. And it's probably honestly going to be left up to the language in the solicitation. If the contracting officer specifically says in the solicitation, hey, you need to be certified, you need to have your CMMC status independently verified, for example, at the time of submission, then that's got to be the case too. Otherwise, we're not following proper procedures.
Yeah, and a TTP on so many things, but it sounds like this included exactly what you said, a time-stamped screenshot. That's always going to help your KOs back up their position. This is the date and time in which I got the information that I'm citing here. It's going to protect them 5 different ways. So not just in this, but as a good common practice when setting up the contract file.
Yeah, Ed, and not just that, but again, going back to making the initial determination as to whether or not this is required.
Yep.
Maybe this is really only a tier 2 instead of a tier 3, right? So we're going to have to make sure that we're justifying that requirement.
That's right.
Okay, so that all sounds good. Documentation is always key, especially when it comes to protests. But let's talk beyond protests. What happens after the contract is awarded? What new enforcement tools does this actually give the government, though?
Yeah, so this is where CMMC really changes the stakes for the contractors, right? What's not new is that a failure to maintain these cybersecurity standards is a breach of contract. However, formerly, we relied on that self-certification, and now the matter is verifiable by a third party and enforceable under this new clause. This gives the government grounds for remedies ranging from a cure notice all the way to a termination for default or cause. It also prohibits the contracting officer from exercising an option if the contractor certification has lapsed, which is a pretty powerful tool to ensure continuous compliance.
So in the past, I've been able to, or I've worked a lot around the False Claims Act. How does the CMMC change the False Claims Act landscape for the government perspective?
It's really just a strengthening mechanism, right? The rule requires a senior company official to annually affirm their ongoing compliance in SPRS. That annual affirmation creates a direct and powerful basis for FCA liability. If a contractor submits invoices while knowing or in reckless disregard of the fact that they are not compliant, each of those invoices can now be treated as a false claim. This is a massive enforcement lever, especially with the Department of Justice's Civil Cyber Fraud Initiative actively looking out for these cases.
This is a lot for the acquisition workforce to absorb, right? As a government attorney, what is the most important piece of advice you can give for navigating through this new environment?
That's a tough one, Ed. What I would suggest to start with is getting comfortable with the definitions of FCI and CUI, so that if you understand that the contracts you're going to be advising on involve those 2 types of information, then you're going to need to know the tiers and what all comes with it. Okay. You don't necessarily need to dig into every NIST standard and understand every nuance, but you need to be comfortable with, hey, is the KO sufficiently guided and in their decision to require these tiers? And
so that's what we talked about earlier. I could find in both the program rule and the clause rule. Is that right?
You got it, Ed. Except those are like the difficult things that we do at the outside to make the rules. So if you're a practitioner and you're dealing with a lot of stuff on your desk, just jump in the DFARs. You'll go to the FAR for FCI. You'll go to the DFAR for CUI and the clause rules.
So Jason, do you think this is actually going to change anything, though?
That's a great question. In my experience, maybe not, but maybe. I think this is a step in the right direction for sure. And it is a big requirement for contractors to try to comply with. And so to that extent, we may get some paring back of these requirements. But if it works out enough and the contractors are comfortable with it, then they may do really well. And so time will tell.
And Jason, sorry, but just as a quick reminder, when does this actually go into effect?
Yep, so the new clause should be incorporated into the DFARS and along with all the other information surrounding CMMC on November 10th, 2025.
This has been incredibly helpful, Jason. It's clear that for government attorneys, CMMC isn't just another clause. It's a fundamental shift in how we procure, manage, and enforce cybersecurity.
Exactly. It's a new set of tools, a new set of risks, and it requires proactive legal engagement to be successful.
Thank you for joining us today in this episode of Far and Beyond. Please make sure to follow us and subscribe to your favorite podcast platform.
We love to hear from our listeners. Please continue to reach out to us on Facebook and LinkedIn. The information can be found in the show notes from today's episode.
The views expressed today are those of the presenters, not that of the Judge Advocate General Corps, the Department of the Army, or the Department of War.